A very warm welcome to this latest in the series of Farrar's building webinars that we've been holding since lockdown began. For those of you that don't know me, my name's Joel McMillan and I'm one of the juniors here at Farrar's. Most of my practice is personal injury, and as part of that I do a fair amount of employers' liability cases, and it's about employers' liability that I'm going to be speaking today. Just before I get started, I just want to flag to you that at the bottom of your screen, there is a little button that says Q&A. And if you click on that, you can type in any questions that you may have for me. Nobody else will be able to see those questions but me. And what I will do is I will answer them all at the end of what I have to say rather than interrupting my flow as I go along. So I thought it might be helpful for me to say something about employers' liability for two reasons, really. The first is that, as no doubt you know, the landscape of employers' liability has, at least in theory, changed quite significantly in the last few years with the enactment of Section 69 of the Enterprise and Regulatory Reform Act 2013, which had the effect that civil liability no longer attaches to breaches of the so-called six-pack regulations, those regulations that were passed pursuant to the Health and Safety at Work Act 1974. And so rather than bringing claims for breach of statutory duty, claims now, on the whole at least, have to be brought in negligence. And I think it's fair to say that there is a lack of clarity at the very least, and maybe even a degree of confusion as to precisely what the effect of the enactment of Section 69 has been and how much things have really changed. And the second reason why I thought it might be helpful to say something about employers' liability is because although we're all familiar with the concept of negligence, the way it's applied within the specific context of the employer-employee relationship is a little different and perhaps surprising when compared to how it operates within other contexts and within different relationships. So they're the 2 points I suppose I want to focus on this afternoon. But before I get to that, I thought it might be helpful to just remind ourselves of some basics. Now, if you open a textbook on personal injury or something along those lines, you'll almost always find a separate chapter dealing with employers' liability, which can sometimes give the impression that it's somehow a separate tort or something entirely different from negligence. And certainly when I started in practice, I know that I found employers' liability cases a little bit intimidating and felt not particularly confident of what was going on. So I think it's helpful to remind ourselves that it's not a separate tort. It is, well, prior to the enactment of Section 69 of ERRA, so pre-2013, it was primarily a breach of statutory duty like any other breach of statutory duty. And since ERRA, it's now primarily about negligence. And the principles of negligence are no different in general terms within the context of employers' liability as they are anywhere else. And to re-emphasize that point, I have that quote from Lord Hoffman from White, Chief Constable of South Yorkshire Police, in which he said, "The liability of an employer to his own employees for negligence is not a separate tort with its own rules. It is an aspect of the law of negligence." And so those fundamental principles of negligence that we're all very familiar with, so duty, breach, causation, foreseeability, remoteness, and so on, all apply as much to employers' liability claims as they do to any other type of claim, as indeed do the defences that are available to a defendant in any other negligence claim. So contributory negligence, for example, applies just as much in an employer's liability claim as any other type of claim. So just to be absolutely clear, when there are cases of employer's liability, there are two ways in which liability can be established by a claimant. The first of which I'm not really going to talk a great deal about today. That's vicarious liability, primarily because, as you may well know, it's a pretty extensive subject by itself and probably warrants its own webinar. But in general terms, what we're talking about there is vicarious liability for other employees acting within the course of their employment. So if you are an employee and a fellow employee, whilst acting in the course of their employment, performs a negligent act, then as well as suing that employee, who, let's be honest, is unlikely to be insured or unlikely to be able to pay damages to you, you can sue the employer as well, who will be vicariously liable, i.e. vicariously responsible for the actions of that other employee. So that's one route to establishing liability within the context of employer's liability. The other route is a breach of the employer's own duty. So as well as your fellow employee's own duty to you that can be breached and lead to a vicarious liability claim, the employer has its own duties that it owes directly to you. And it's that we're going to concentrate on today, the employer's own duty. And as you will see that I've underlined, that duty is a non-delegable duty. And this is a really important feature of the employer's duty. So what that means, I think it's sometimes easy to use these words without perhaps fully understanding what they mean. What that means is that the employer can't ask somebody else to fulfill that duty on its behalf, or it can rather, but it will still be responsible in law for that other person completing that duty. So for example, it's part of the employer's duty to maintain a safe place of work, and is of course open to an employer to delegate the act of cleaning the place of work to a third party. So for example, to an independent cleaning contractor. However, if that third party cleaning contractor performs that duty or performs that act negligently, leaves, say, water on the floor, and an employee slips over and injures himself or herself, then it's no defense to the employer to say, well, it wasn't me or one of my employees cleaning the floor, it was a third party contractor. And what's more, that third party contractor was a professional cleaner. The responsibility and therefore the liability still rests with the employer directly, which has obvious benefits to the employee. They can bring a claim directly against the employer, but of course it leaves the employer in a more difficult position. Although of course in the scenario that I've mentioned, the employer will no doubt want to consider seeking a contribution or an indemnity from that third party. But the key point is that unlike, for example, in occupier liability cases, it's no defense for an employer to say that it had subcontracted, if you like, the responsibility to a third party. So the duty that's owed by the employer directly to the employee was expressed by Lords Reed and Hodge in a Supreme Court decision of Kennedy and Cordia LLP back in 2016 as: the ruling principle is that an employer is bound to take reasonable care for the safety of his workmen, and all other rules or formulas must be taken subject to that principle. And I suppose they're making the point that the duty is a general one, and that in order to analyse the duty, one needs to have the specific facts at one's disposal. It's a very fact-specific type of scenario. That being said, there have been various attempts in various cases down the years to analyse that duty in a bit more detail and break it down. And one analysis of that overarching duty that has proved to be particularly influential is that by Lord Wright in the case of Wilson and Clyde Coal Limited and English. And taking account of changes in language, he broke it down into the 4 elements that you can see before you. So safe and competent colleagues is the first one. I should say that this now is less significant than it was at the time that Lord Wright was giving his judgment, because in 1938, when he was giving his judgment, employers weren't vicariously liable for the actions of other employees. So in circumstances that I described earlier, where one employee is injured by the act or the negligent act of a fellow employee, the employer wasn't at that time vicariously responsible for the negligent act of the fellow employee. So the only route to establishing liability against the employer in those days was persuading the court that they hadn't taken reasonable care when choosing the colleagues to appoint, and hadn't carried out a proper recruitment process or check references or whatever. So that's a much less significant part of the duty now that there is vicarious liability, but it's not entirely irrelevant. It can still have some application today. So for example, an employer won't be vicariously liable for an independent contractor, but an employee might be able to establish that the employer didn't take reasonable care when appointing that independent contractor, and therefore was left with a colleague who was a danger to his safety, and may succeed in that way. So as I say, safe and competent colleagues is probably the least important element of the duty that Lord Wright identified back in 1938, but nevertheless is not entirely relevant. The other 3 are a little bit more straightforward. Safe equipment, I think, is pretty self-explanatory. Safe place of work, again, is reasonably self-explanatory. Although I should say that it includes both access and egress to that place of work as well. And then finally, number 4 is a safe system of work, which I suppose is a bit of a catch-all, and nowadays would include things like risk assessments, method statements, PPE, supervision, and the like. So that, in a nutshell, is the duty broken down into 4 broad headings. Obviously, beneath that, there's extensive case law on what all that means in practice, which I'm afraid I don't have time to go into today. But what I do now want to move on to is how negligence in general terms is applied within the particular context of the employer-employee relationship. So I had just said towards the beginning of my remarks that it's important to remind ourselves that we're dealing with negligence, and the ordinary negligence of principles apply. But having said that, I think it's careful not to be lulled into a false sense of security. We're obviously all PI practitioners, and we all no doubt feel that we have a fairly firm grasp on the principles of negligence and how it's generally applied. But of course, the tort of negligence is about taking care that is reasonable, and what is reasonable is always going to be very specific to the context. And I think, particularly when one first starts out, it's quite easy to misjudge how the principles of negligence might be applied within the context of an employment situation. So to give an illustration, I want to talk very briefly about the case of Casson and Spot Mix Limited, which is, as you can see, is a 2017 case in the Court of Appeal. It's not in any way a groundbreaking case, and it doesn't set out any new proposition of law, far from it. But I think it illustrates the point that I have been and will continue to make. So the facts are of the case that Mr. Casson was working in a factory, and he cleaned a metal sheet in a industrial machine that was, and this sheet was located very close to some large rollers on a large industrial sized conveyor belt. And whilst he was cleaning, his sleeve got caught in the rollers and unfortunately he was injured. Now, at first glance, I think it's fair to say that it was perhaps a slightly risky and even foolhardy thing for Mr. Casson to be doing, reaching in to clean a piece of equipment in very close proximity to moving large industrial machinery and applying the usual rules and principles of negligence. One, I think, perhaps might think that Mr. Casson could be described as the author of his own misfortune, that what he was doing was obviously risky, and that even if primary liability attached to his employer, then there would be a strong argument for a high degree of contributory negligence on the part of Mr. Casson. Well, the case at first instance was heard in the High Court, and primary liability was found to attach to the defendant, and there was indeed some contributory negligence found on behalf of Mr. Casson. But that contribution was said only to be 10%, so relatively speaking, a really very small amount of contribution by the claimant. The case went to the Court of Appeal, which overturned the trial judge's findings and held that in fact there was no contributory negligence at all on behalf of Casson, and that therefore his claim succeeded in full. And so I say that this is an example perhaps where one has slightly surprising outcome perhaps when one considers how negligence principles, one might expect them to be applied within the context of an employer-employee relationship, and how they actually are applied by the court. So I suppose the question to ask oneself is what's going on here? What is it that's underpinning these outcomes that on the face of it seem to be slightly different from negligence as we know it? And the answer is this, is that the courts are taking an approach that reflects the fact that an employer exerts a very large degree of control over an employee when he or she goes to work. So when you go to work as an employee, obviously your employer pretty much dictates where you go to work, dictates when you go to work, dictates what work you do, how you do that work, who you work with, the equipment that you use to do that work, whether you're provided with personal protective equipment, and so on. And so the employer has a very significant degree of control over you as an employee, and you as an employee have very little say in how it is that you go about doing your work. And the upshot of that is that the courts place a pretty onerous duty on employers when it comes to looking out for the health and safety of their employees at work. More so than one may find indeed in other contexts, other relationships that are not employer-employee. And the case of Kennedy and Cordia services, which I mentioned before, is a helpful illustration of this. So the facts of this case are that Miss Kennedy was a carer, and as part of her job she went from into people's homes, caring in people's homes rather than in a care home. And the case was up in Glasgow, and it was winter. Miss Kennedy was visiting one of her patients at their home. It was cold, snowy and icy, and as she walked up the path to the patient's premises, she slipped and was injured. Now, she succeeded at first instance, but the case went on appeal to the appeal court in Scotland. And the appeal court there took the view that given the occupier of the premises, so the patient, couldn't reasonably be expected to, for example, have cleared the path or have undertaken any other acts to provide additional protection to Miss Kennedy, then similarly, it was unreasonable to expect the employer, the defendant, to have done anything in addition to protect Miss Kennedy from slipping and falling over on the path. And in this particular case, what was suggested should have been done was providing Miss Kennedy with some metal attachments to place on the soles of her shoes to provide additional traction and grip when walking up and down the icy path. That then was appealed down to the Supreme Court in London, and what Lords Reed and Hodge said in giving judgment for the court was this: unlike an ordinary member of the public, she was obliged to act in accordance with the instructions given to her by her employers. Employers who were able to consider the risk to her safety while she was at work and the means by which those risks might be reduced. In those circumstances, to base one's view of the common law on the premise that Miss Kennedy was in all relevant respects in the same position as an ordinary member of the public is a mistake. So because of that degree of control exerted by the employer, the duty on the employer is much more onerous and much higher than, as in this case, within the context of an occupier and visitor. So to summarize, the effect of that context that I've just been describing is that the standard of care is high and higher than one would expect in different situations. It's a duty that is non-delegable. As I've already mentioned, it means the result is that liability may well attach to an employer where on the same facts liability wouldn't attach to a party in a different relationship with a would-be claimant who nevertheless owed them a duty. It also means that omissions are much more likely to be a basis of establishing liability than they are in other contexts. Generally, omissions are less frequent, shall I say, as a basis of establishing liability. And also, finally, that the effect I think to point out is that defences, although they're available to a defendant, as I've already mentioned, it's often quite difficult to establish those defences. So if we take, for example, Valenti non fit injuria, which is the defence that essentially a claimant has consented to the risk that they have been exposed to, one can see quite easily that it's very difficult for a defendant to argue that there has been genuine consent by an employee to a risk that he's been subjected to at work, when in reality, the employer is in charge and is dictating to him how he must carry out that work. And for similar reasons, that there are difficulties with contributory negligence, which is, I think I illustrated already in the case of Custom, which I described with the person who got their sleeve caught in the rollers in the factory. So that's the effect of I suppose, the general context of the employer-employee relationship, and I hope I've illustrated how that leads to a duty and a standard of care that is quite onerous, and certainly more so than one would expect within other contexts. But the other context, which now makes the application of negligence principles unusual in the case of employer-employees relationship, is the ongoing influence of the six-pack regulations, notwithstanding the enactment of Section 69 of ERRA of the Enterprise and Regulatory Reform Act 2013. So, as I've already mentioned, the effect of that act was to remove civil liability for breaches of those regulations. And it was very clear from pronouncements from the government and from the debate in Parliament that the intention of so doing was to rebalance the relationship between the employer and the employee within the context of health and safety at work. Because rightly or wrongly, there was a perception that liability had become too strict and that employers were being held liable for accidents at work when it was unfair and unjust. And the case, I suppose, that was most frequently cited as being an example of this was the case of Stark in the post office. Now, Mr. Stark was a postman, and he was obviously employed by the post office, who provided him with a bicycle to carry out his round. Now, under the provision and use of work equipment regulations 1992, the post office, as his employer, was under a duty to maintain that bicycle in good repair. And it carried out a system of inspection and maintenance. And there was never any suggestion that that system of inspection and maintenance was anything other than perfectly reasonable and adequate. But in spite of this system of maintenance and inspection, Mr. Stark was cycling along. There was a fault with part of the mechanism on his bike, which caused his front wheel to lock, and he was thrown over the handlebars, suffering a not insignificant injury. At trial, there was a finding that the cause of the accident was either metal fatigue or a manufacturing defect, and that neither of those could have been discovered by any form of inspection carried out by the post office. And as I said, that the regime of inspection and maintenance by the post office was sufficient to discharge its duty and negligence, or under the common law duty in respect of the equipment. But notwithstanding that, it was held that the duty under the regulation to maintain the bicycle was strict, was absolute, and that by the mere fact that the bicycle wasn't maintained and that it had there'd been a defect with it and it had caused the accident, that in and of itself was enough for the claim to succeed. And as I say, that was seen as an egregious example of employers facing liability when really it was unfair and unjust. And as I say, the expressed intention of Parliament was to rebalance that position, which would have been fine. But I suppose the difficulty has arisen and the confusion has arisen from the fact that those regulations remain in force and employers are still required to adhere to the duties in those regulations. So notwithstanding the fact that if an employer breaches one of those regulations, it won't face, or an employee won't be able to bring a civil case against it for breach of those regulations. Nevertheless, it could still face a criminal sanction for breaching those regulations, which leads, I think it's fair to say, to a slightly curious state of affairs. And so there are now competing views over the extent to which those regulations, whilst they don't give rise or to civil liability directly, but the extent to which they should inform the common law duty. So there's one school of thought that says that if an employer breaches the regulations, then that in and of itself should amount to negligence, and that should be enough for a claim to succeed. Whereas there is another school of thought that says, yes, it's right that those regulations should have some bearing on how the courts interpret the common law duty owed by an employer. It goes far too far to say that, in effect, the law hasn't changed at all, and that a much more nuanced approach is required. And there's no clear answer to that. in the case law. And I think it's fair to say that there is a degree of confusion amongst practitioners when dealing with these type of cases as to how to plead them and how to present them when they get to court. I mean, certainly I know that if I'm pleading a claim on behalf of the claimant, then I will plead all the breaches of relevant regulations that I can think of and suggest that such breaches are tantamount to negligence and are sufficient for a claim to succeed on that basis alone. Whereas if I'm acting for a defendant and pleading a defence and I'm faced with pleading like that, then I know that I will be suggesting that in effect the regulations are irrelevant and that you, the claimant, need to bring your claim in negligence. You need to establish negligence, and that breach of those statutory duties isn't going to be enough. So as I said, there's no real clear authority on this particular question. There are two. The issue has been dealt with twice in High Court decisions, certainly as far as I'm aware, no more than that. In both cases, they were cases heard by deputy High Court judges, so not as authoritative as they might be, and unhelpfully, they disagreed on the point. So the first case was the case of Cockerill and CXK Ltd, with Rowena Collins-Rice sitting, as I said, as a deputy High Court judge. And she said that by enacting section 69 of ERRA, Parliament evidently intended to make a perceptible change in the legal relationship between employers and employees in this respect. It is no longer enough to demonstrate a breach of the regulations. Not all breaches of the statutory regime will be negligent. And I think it's fair to say that has an obvious degree of logic to it. It would seem odd if Parliament had gone to the trouble to enact section 69 of ERRA and that the law hadn't changed at all. And I suppose as an illustration of how the law had changed pre and post 2013, I should tell you a little bit about the case itself. So the case involved an employee being sent by the employer to a third-party premises. It was controlled by a third party to carry out some of their functions at work. Now, the employer didn't carry out a separate risk assessment of those premises. Rather, it relied on a risk assessment that had been carried out by the occupier, so by the third party of those premises. And one of the suggestions, or one of the allegations made by the claimant, was that there had been a breach of the management regulations by the defendant, by the employer, in failing to carry out its own risk assessment and instead rely on the risk assessment of the third party. Now, this ultimately wasn't a matter which was determinative of the case, and Rowena Collins-Rice didn't have to make a particular finding on it. But what she did say that if she had found that there'd been a technical breach of the regulations in failing to carry out that separate risk assessment, then as far as she was concerned, that would not have been negligent and therefore would not have been enough for the claim to succeed in the post-ERRA world. The second High Court case was the case of Tompkins and Tapp. This time it was His Honour Judge Gore QC sitting as a Deputy High Court Judge, and his remarks were made obiter, which of course gives them less weight than they might otherwise have had. But the key point is that he expressly disagreed with what had been said in Cockerill. And he said that if a breach of the regulations in itself did not amount to negligence, the result would be to emasculate the statutory duties. That cannot have been parliamentary intention in 2012, For if that had been the intention, Parliament would instead have chosen to repeal the statutory duties in question. And again, I think it's fair to say that there's a certain degree of logic in that position, because how can it be that there are statutory duties on the statute book that require employers to take certain actions to protect the health and safety of their employees, but if they breach those duties, then it's reasonable to do so, and they're not negligent. That also doesn't, in many ways, make a great deal of sense. So where does that leave us? What is the best way of seeing the impact on ERRA as things stand on employers' liability cases? Well, a lot has been written about the impact of ERRA and what the correct answer is to the question that I've just been talking about. But in actual fact, I think it's very easy to overstate the importance of that question. In fact, I'm pretty skeptical as to how much difference it will actually make, certainly in the vast majority of cases. I think it's notable, first of all, that Cockerill, or neither Cockerill nor Tompkins, were appealed for the simple reason that in neither case was this issue determinative of why on both occasions, as it happens, the defendant was successful and the claim failed. And I think it's also significant that there's been no authoritative case dealing with this particular question. I appreciate that it's only 7 years since ERRA was passed and that things take some time to filter through, particularly for things to get up to the higher courts. But nevertheless, it is a considerable amount of time that has now passed. I think a large reason for that is that simply it's going to be largely academic, this question, when applied to the overwhelming majority of cases. And the reason for that I would argue at least, is that there is actually no question that the regulations will continue to inform the common law duty. So even in Cockerill, where Melissa Collins-Rice had said that there had been a marked change since 2013, she accepted that that's the regulations, continue to be relevant to the question of what an employer ought reasonably to do. Obviously within the context of a negligence claim. And in Kennedy, which is the Supreme Court decision I mentioned earlier on, Lords Hodge and Reed said, the expansion of the statutory duties imposed on employers creates the context in which the court has to assess an employer's performance of its common law duty of care. In other words, the negligence and the common law duty has in effect developed as the statutory duties have developed alongside it. And most notable perhaps about Kennedy is that for the first time in that case, it was recognised that there was a common law duty to complete a risk assessment. This wasn't something before the introduction of the six-pack regulations, but it then became commonplace under the regulations. And as it became part of the, I suppose, a new context within which employers and employees worked, it was then adopted by the common law. And so I think any suggestion that somehow 30 years of working practices since the introduction of the six-pack regulations would somehow simply disappear because of the enactment of Section 69 was never going to be a realistic proposition. And the content of those duties in the regulations is inevitably going to be hugely relevant to determining the scope of the duty at common law of an employer. The other point to make, or another point to make, is that in spite of all the focus on Stark and the strict liability that attached in that case, many of the regulations, in fact, don't impose strict duties, but are phrased in terms such as far as is reasonably practicable. So the duty is not absolute, it's not strict, as I've just said. And although it's not identical to negligence, it's obviously not hugely different. Reasonable care and as far as reasonably practicable, as I say, not it's different wording, but it's not conceptually that different. And so I think the number of cases where one or a claimant would establish that the defendant has failed to comply with a regulation or a duty as far as was reasonably practicable, but fails to establish that has not taken reasonable care to comply with that duty, are going to be very few and far between. It seems to me to be an exceptionally narrow set of circumstances where that finding might arise. And indeed, it strikes me as a particularly challenging argument to have to make as a defendant's counsel. And it may be the case in reality that there is no appreciable difference with how those cases are determined. And I think, so yeah, to repeat, I think they're going to be very few and far between, those cases where there is in fact a real divergence between pre-2013 and post-2013. And even looking at Cockerill, which is the case with the risk assessment I was talking about a few moments ago, I'm not actually convinced that pre-2013 it would have been determined any difference, because it seems to me that there is an obvious causation issue with any breach to carry out a risk assessment by the employer, but instead relying on a third-party risk assessment, which it seemed to have been accepted was an adequate risk assessment. Because if the breach was that the employer had failed to carry out its own risk assessment, then obviously one has to then go on to prove that that has caused the accident. Now, if in reality the third party has carried out an adequate risk assessment and the employer is simply relying on that risk assessment, then the obvious inference seems to me to be that the employer's risk assessment wouldn't have been materially different, and therefore there wouldn't have been a different outcome, and so any breach therefore wasn't the cause of the claimant's accident. I suppose the most obvious difference where the one might see is in respect to work equipment, and as I've already mentioned, Stark was the case that was always held up as the great example of a case where the outcome had been unfair on the employer, and that was because liability in respect of work equipment was held to be strict. But again, I'm not sure how much in reality has changed or is going to change as a consequence of ERRA. And the reason for that is this act that was quite obscure pre-2013, because there was simply no need to refer to it with the regulations that were in force. But it's an act that has survived Section 69 of ERRA, so it's still in force today, and it still gives rise to civil liability. And you'll see that it's the Employers' Liability Defective Equipment Act, 1969. And what it provides is that if an employee suffers personal injury in the course of employment in consequence of a defect in equipment provided by his employer for the purposes of the employer's business, and the defect is attributable wholly or partly to the fault of a third party, whether identified or not, the injury should be deemed to be also attributable to negligence on the part of the employer. So as always, these acts are sometimes a little bit difficult to understand. So to cut through that a little bit, if you have an employee who is injured and the cause of that injury is a defect in equipment that has been provided to him by his employer, and that defect is caused by the fault of a third party, whether that third party is identified or not, then that injury will be deemed to be attributable to the negligence of the employer. In other words, an action against the employer will succeed in negligence. Now, obviously, that doesn't impose strict liability in the same way that the regulations did pre-2013, but it does, in my view, appear to give a pretty wide scope for an employee who's been injured by defective equipment at his or her work to bring a claim against his employer, because all it requires is anybody to be at fault, whether whether or not that person is identified or not. And it seems to me that in many, if not most, or close to even all cases, there's going to be an argument, perhaps a strong argument, that if you're at work and you're injured because there's a defect in the equipment that you're using, something must have gone wrong somewhere, either in the design of that equipment, the manufacture of that equipment, the maintenance of that equipment, the repair of that equipment, and so on. And so again, I wonder really how much has actually really changed with the enactment of ERRA in section 69. And to refer back to Stark, which is the case with the bicycle, one of the findings in the case was that the cause of the accident may have been caused by either a weakness in the metal, stress in the metal, or a manufacturing defect. Now, on those facts, applying the 1969 Act, if a judge was pushed to make more specific findings and find, for example, that it was a manufacturing defect, although the post office still wouldn't be negligent in the sense that they had actually been at fault themselves, under the 1969 Act, then any negligence or other fault by whoever had been involved in the manufacturing process would be sufficient for Mr. Stark to still succeed against the post office. So, as I say, I wonder whether in actual fact that case would have been decided any different today as it was back in 2000. Okay, so that concludes what I wanted to say about employers' liability. I appreciate that it's been a bit of a gallop through some of the principles of that area of law. I hope it's given you some kind of context for when you're dealing with employers' liability cases, and I hope it's been of some help. In a moment, I will see whether I've been asked any questions, but before I do that, I just wanted to say a couple of things. First of all, you will automatically be emailed a recording of this webinar. So should for any reason you wish to watch this again, perhaps you've run out of things to watch on Netflix, you'll have the opportunity to do so. And the second thing that I wanted to say was that these webinars are now taking a summer break, so there won't be any webinars in August, but I know my colleague Aidan O'Brien is back on the 1st of September with a webinar on expert evidence, medical expert evidence within the context of personal injury and clinical negligence claims. So keep an eye out for that at the end of summer. So let me have a look at the questions that have been asked. One person asked about the Employers' Liability Defective Equipment Act, which I suspect he was asked before I got onto that point at the end, and he or she was asking about whether stock in the post office would actually have been that different. And I think I've answered that question. He or she obviously shares my views. Another question is, how will the recent rise of working from home affect the employer's responsibility to provide a safe place of work? And I think that's a really good question, isn't it? Because it seems, well, obviously in the last few months, many more people have been working from home than have been before. And everybody seems to be assuming that this is going to continue, that people will be working from home much more than they will be in future. And I suspect this is going to be something that's going to be tested in the courts before too long. As always, the guiding principle is going to be what amounts to reasonable care in all the circumstances. But it does seem to me that an employer might be in some difficulty if it doesn't give an employee the option of a place of work away from their home. And for example, there's somebody who is in a house share, is in a bedroom, having to work at a laptop all day without space for a proper desk and without space for a proper chair. It does seem to me that there are potentially going to be difficulties for employers, and no doubt they will have to come up with ingenious ways of doing what they can to take reasonable care for their employees' health and safety. But it does seem to me that if you're forced to work sitting on your bed at a laptop and you develop backache, and your employer hasn't made any kind of provision for any kind of desk space or proper chair, I think we may see certainly some test cases and perhaps quite a bit of litigation in respect of that, particularly as it becomes more embedded. Of course, there's only so much, I suppose, an employer can do within the immediate few weeks or months immediately after lockdown. But as these new practices become more embedded, then I think that the courts will expect employers to probably do a bit more. Next question I have is, some breach of the regulations cannot amount to negligence, as some of the regulations are strict, and this duty is higher than common law negligence. Therefore, it cannot be said that breaches of the regulations are negligence. Do I agree? I think I do broadly agree, yes. And that's, I think, the point I was making about, for example, the start case, the bicycle case. I don't think that it could be determined the same way purely within the context of negligence, because as the questioner has rightly said, there's no the regulation was strict, whereas negligence obviously must require fault. But as I also think I said, I think it's a bit of an overstatement to not from the questioner, but generally people who have been hugely critical of the regulations, to paint a picture that a very significant number of the regulations were in fact strict. The fact that almost everyone cites Stark as the example, I think, is probably evidence of the fact that not many of the regulations were in fact strict. And so, yes, I agree with the question. Obviously, in that particular context, I've already said that in respect of work equipment, one isn't left entirely with negligence. But yes, where the duty is strict, I do struggle to see how it can be negligence, because in effect you're asking for finding of negligence without any fault. Then I have a final question, which is there a clear line of distinction for normal employer's liability insurance and employment practice liability insurance, and where claims should attach, especially for those involving PTSD, bullying, stress, harassment, personal injury, question mark at work, etc., by other employees. I have to confess, I'm afraid I'm not much of an expert when it comes to different types of insurance. I'm not, if I'm frank, know quite what the difference is of those between those types of insurance. Quite how one is insured is not material to how a court is going to assess a case. The legal principles apply, and then whichever insurance policy is required to cover a particular claim will obviously have to cover that particular claim. But really the question of what insurance policy is in place isn't really a matter for the court, although of course insurance for employers' liability is compulsory and a requirement by law. I hope I've at least tried to answer that question. If I haven't answered that question or quite got to what you were getting at, then please do get in touch with me after this session. You can see on the screen now, you can see my email address. If you want to get in touch with anything about anything that I've talked about today, or you have any further questions, please do so. You can contact me on that email address, or alternatively, you can contact me on the telephone via the chamber switchboard. But otherwise, it just leaves me to say thank you very much indeed for joining me this afternoon. As I say, I hope it's been helpful, and enjoy your evening. Goodbye.